the true long-term goal here was, as the next referendum comes up, as the next initiative carries out, whatever the outcome is, that both sides or all sides will be able to look at the process and say, okay, that was fair, that was reasonable. The outcome was a genuine, accurate reflection of the citizens' desires, whatever they were. So that was the overarching goal, and my hope is that we accomplish that. Now, the things that we were looking to do in this bill, first and foremost, were to stop some of the loopholes, the games, the backdoors, if you will, in the current law. And so on the petitioner side, one of the biggest games they could play was to sit on the signed petitions to the last possible second and then turn them in, so there was absolutely no opportunity for signature removal or any kind of a pushback on that front. And the other game that petitioners could play really is they could, and that kind of goes along with it, they could very openly misrepresent what the petition was about, and there really wasn't any way for the city to counteract that. I mean, not effectively, because there was the whole political activities statute that prevented the city from doing any kind of active information sharing. They could do some, but not very much. It was pretty limited. On the city side, and again, I know I'm in the room with mostly city folks here, so hopefully you won't take this personally. On the city side, we wanted in the bill to prevent cities from trying to run out the clock on different aspects of it. In other words, they had much more specific timelines on the process of specifically a referendum. That was the more controversial thing. We wanted to make sure that cities could not unduly campaign, in other words, use taxpayer resources to launch a campaign against the initiative. And also we wanted to, and this kind of comes into play in the Cottonwood Mall case, it kind of backfired, but it's actually worked pretty effectively in other cases, and that is the city lets the petitioners go through the whole rigmarole of the referral, and then just as they're getting ready to put it on the ballot, I know nobody in this room has done this, I'm sure, say, oh, that was administrative, not legislative, and kind of torpedo the whole thing, and that's problematic. So we wanted to try to basically have a fair playing field that both sides could look at and say, okay, that's a reasonable process. We can operate under those rules and have, let's call it an effective contest between both sides. I mean, obviously it's adversarial. We can't get away from that. That's the whole point of an initiative or a referendum, is there's some adversarial element to it. And so that happens, but can we keep it to Queensberry rules? Can we keep it fair and understandable? And so a couple of other things that we were trying to accomplish in House Bill 119 was, if there was a question about getting information to the voters in any way, we wanted to err on the side of making sure that voters were fully informed as much as possible. And if we were going to use taxpayer resources to get information to the voters, which I think is fair, I mean, we all see at the state level, the lieutenant governor puts together a fairly thick voter information pamphlet, and that's paid for at taxpayer expense, and everybody thinks that's a good idea. We wanted the same kind of idea at the city level for referendums and for initiatives. And so again, we want those city resources, those taxpayer resources, to be used to get information out there. The only caveat, which is a fairly important caveat, is you wanted both sides to have access to that conduit. We wanted both sides to be able to have their say in that information pamphlet, so when voters got information, they were hearing from both sides. Now, one of the things that did was, rather than have this kind of vague term where cities could put out information but couldn't campaign, they could do this and they could do that, we said, look, just kind of say what you want to say in your 500 words. Make your best argument, whatever it is. We're not going to try to nitpick it and go to court about whether you're a campaign or not. Just make your argument. Well, the other side make their argument, you put in your rebuttal, they put in their rebuttal. That's a very new aspect in House Bill 119, and that gives the voters, a kind of a straight up comparison between the two sides, and they can make the decision based on what both sides are saying. And we don't have to do any true check or anything like that. We're hoping the other sides will do that for each other and all that stuff. So again, trying to avoid that. And the other thing that we really wanted to do here, and this goes back to things that we're seeing at the legislative level, and that is that oftentimes This kind of an action by citizens is a reaction to a perceived indifference by a legislative council. We certainly can plead guilty to that as a Utah State Legislature. There are some issues on which we have turned a deaf ear, at least looks like we've turned a deaf ear. And so we want there to be this opportunity for both sides to come together in good faith and discuss, okay, we understand your concern. Are there ways that we can address that concern? Are there things we can do to compromise, to come to an agreement and understanding before this actually goes out to gathering signatures, before you go to the expense and the hassle of gathering signatures, all right? And so built into the bill is and Cameron's going to tell me if I get the numbers wrong, is a 20-day pause? 20-day pause, during which a couple of things happen. Both sides have the opportunity to get together. It actually says that in the bill. We can't mandate they get together. The other side may just say we don't want to. But at least there's the opportunity for both sides to come together, to look over the referendum or the initiative. And of course, this plays more in a referendum arena than anywhere else, and decide or talk it over and see if they can't come to some understanding, and possibly have the city go back, modify the ordinance, in accordance with the compromise, or at least just come to an understanding. So that happens during the 20-day pause. And the other very big thing that happens during the 20-day pause is the city at that point in time, or the county, has to determine and has to state up front if they feel that the action being referred is legislative or executive. And of course, if they decide at that level that it's executive, then they have to at least begin the process of taking it to court if the other side decides to fight it, and begin the process of looking through that. And you think about that in the Cottonwood Mall case, that would have jump-started the case by a significant amount of time, and very likely, hopefully, depending on the Supreme Court, which we can't dictate their timeline, but at least there would have been the opportunity before this went to a vote to see if it was legitimately legislative or not, and to see, again, since only parts of it were deemed legislative, which parts were legislative and therefore subject to referendum. And so by the time, hopefully, you get to the actual vote, you got those questions all answered. And that saves both the city a lot of time and hassle, that saves petitioners a lot of time and hassle. So trying to get those things done all up front. So again, bottom line is we want to make sure that both sides understand the rules. We want to make sure that there's a fair opportunity for both sides to be heard. We want to make sure that voters are fully informed. And at the end of the day, one other thing I need to touch on really quick. The other thing that this is asked for by the clerks, which I liked, the idea was that during the course of gathering signatures, petitioners have to turn those in as they collect them. And in order to make that easier, we said, okay, listen, this is not 1962, this is 2019. Take a picture of the signature page with your cell phone and send it to an email that's been designated for you. For the most part, clerks are like, yeah, we can work with that. We want to see the paper at some point, but if we just have a scan, we're going to scan it anyway because we're going to want to look at it closely. And that way, petitioners just have to take a picture, email it in, and the petitions and the signatures can be verified along the way. That makes it easier for the clerks to do it on the way, and it also, frankly, makes it easier for those wanting to remove those signatures. It gives them a fair access to it, so that if there was any misrepresentation, if people change their minds, they have the opportunity to remove those signatures. So that's another aspect of the bill that we passed. So let's see, bottom line, make it fair for everybody, full information to voters. At the end of the day, everybody can feel like at least the process was fair. And I'm happy to take any questions you might have. Yes?
Representative Daw, there's a part of the bill that talks about that all legislative decisions made after April 15th are now put on the following, if I'm reading it correctly, the following year's election.
Yes.
To me, that causes some concern just because we have to wait so long. So if I understand right, any decision made now is now pushed onto the ballot in 2020 instead of 2019.
That's one of those nasty, bad things that we have to do in government called compromise. And the fact is, if we want to hold to that timeline for the pause and the signature gathering, we just need that much time. in order to do it. In other words, if we were to shorten that up by any substantial length, we'd have to pinch up the timeline, which of course petitioners wouldn't like, because that would cut down the amount of time they have to gather signatures, and it would cause all kinds of problems. So frankly, all we did there, that there's no magic to that particular date. It's just that we looked at the timeline that we had in place, dictated by the bill, which was a timeline agreed to by pretty much everybody, and said if we work backwards from when the election date was, this is the cutoff for the given year in order to make it work. So, is it perfect? Of course not. We'd love not to have any, as a city, you'd like to have not anything referred at all. But, if we're gonna do it, that's just kind of the way it has to work. Oh, yeah, please.
Aaron, thanks for bringing up the question, because what Representative Daw has explained is right for one type of referendum, but there are two exceptions to the timeline that Representative Daw laid out. One exception is for a land use referendum, and the other exception is for a truth and taxation hearing referendum. And both of those have deadlines that are more compressed to get them on the ballot in the same year, so long as the legislative action occurred by the end of August. So in those two examples, the policy issue that was being balanced was the question of timing and signature gathering and getting the information out, with just the question of a city budget potentially being held in limbo for over a year. And I know there are people here from one particular city who had that happen to them. And from a land use perspective, having a land use zone or land use decision held up in limbo, and the property owners held in limbo, and everybody waiting for that. So in those two cases, condensed time frame. For all the other types of referendums, it's that longer April 15th time frame.
So again, the idea there is let's make the timeline, let's make it as close to the election as possible, but with respect to those other timelines in place. So yeah, other questions? Allow them to sleep. That's your job, not my one. I did say there's one other aspect of the bill that, two other aspects, you can get into these, but just wanted to mention, and one of them is we changed the threshold. It's right now it's calculated off presidential elections or participation in presidential elections, which given who's on the ballot, that kind of goes like this, or even the city, for example, Park City might be a lot less excited about, say, Mitt Romney or Donald Trump than Orem, all right? And so rather than that, we went to active voters, so it's a percentage of active voters, and then we adjusted down that percentage so that numerically, in any given jurisdiction, it's roughly the same number, but it's a much more stable number we work off of. And then, except for really small jurisdictions, the other thing we did was put in the voter participation area. So you not only have to gather X number of signatures, you have to gather X percentage from each participation area, or 3 out of 4, right? Participation areas in order to qualify for the ballot. So, a little bit of a kind of an even thing on one hand, the number, but a little bit of a raise of the bar on the other hand for participation there. So, anyway, that's all I had. I can answer questions that come up, but again, thank you for having me here today. I appreciate it.
So are you saying that truth in taxation?
The question was, can a truth and taxation proposal and adoption be referred? And the answer is yes, that can be referred, because the budget is the quintessential legislative act, and so that can be referred. The question for us became, if that gets approved by the legislative body in August, but then it doesn't qualify for the ballot until the following year, you put a city or a county in a situation where they are budgetless for a year, and that's not good for the taxpayer, and it's certainly not good for the local government. And so the time frame is a little bit different for the truth and taxation / budget referendum. By a quick show of hands, how many people here have first-hand experience with a referendum? And put them high, raise them high and just look around. So from my vantage point, that's about half. Yeah, Wade, raise your hand. Or do you want me to show the scars on your back? Yeah. What we've recognized over the last few years at the League of Cities and Towns is that local referendum and local initiatives are becoming more and more common. Over the last 2.5 years, we've had an internal working group that has been looking at all aspects of local initiative and referendum. So House Bill 119 didn't happen overnight. The first conversation that I had with Representative Daw was actually in November of 2016, where we sat down with him and said, we recognize you have these concerns about the ways that cities may or may not engage in referendums. Well, we have these concerns about timelines. We have these concerns about process. We have these concerns about thresholds. We have these concerns about the perception of handcuffs that stifle the ability of elected officials to explain why they voted the way they voted. Are you willing to take a step back from your one particular concern and tackle this comprehensively? And we, on behalf of the league membership, are grateful that he said yes. There were certainly times over the last 2.5 years, I'm not sure you were grateful that he said yes, but we certainly are. We had multiple meetings with a work group over 2.5 years that included not just the League of Cities and Towns, but local elected officials, city clerks, county clerks, city administrators, city attorneys, the Land Use Task Force, which includes representatives from the Property Rights Coalition and developers, city attorneys and others, the Lieutenant Governor's Office, and even meetings where Representative Daw facilitated meetings between us on the government side with petitioners and people who have experience organizing referendums. So there was a concerted effort over 2.5 years to try to understand the big picture of referendum. Last week we were presenting to the Utah Municipal Attorneys Association about this bill, and I had several attorneys who said to me that they liked certain parts of this bill and they didn't like others. And so I told that to Representative Daw earlier today, and he was very proud of that response, because ultimately, if you were to ask people with experience organizing referendums, they would tell you the same thing about the bill. But what we were trying to do was modernize the process, and we'll have some technical expertise here later this afternoon that will go into those details. We were really focusing on this concept of equal access and equal opportunity to present information. Our board of directors, which at the league consists of 21 elected officials from around the state, were adamant that referendum needed to be a top priority for the league, and the primary aspect was not to make referendums harder, but the primary aspect needed to be to empower elected officials to explain why they voted the way they voted. Ultimately, a referendum is a confrontation about a legislative act that elected officials have adopted. And there's been a chilling effect up through today, because now House Bill 119 has become law. Chilling effect up to today, which made it now difficult for elected officials to respond to questions from constituents, for city staff to respond to questions from constituents about a referendum, to even use your public email to communicate with constituents. Now notice, I didn't say anything about campaigning, because Representative Daw is right. There's a difference between actually being out there campaigning versus actually communicating and trying to educate folks. So I'm going to take just a moment and talk about this communication piece, and then you heard Representative Daw talk about voter participation areas, which is another key component. Wade, I'll let you talk about that piece. The key takeaway on communication is this. The general rule in House Bill 119 stayed the same, namely that a public entity may not use public funds to influence a ballot proposition. And influence means advocate for, against, or campaign for, against. So that general rule is still there. But there are more exceptions that provide clarification for what you can and can't do. For example, you're going to hear later today about the proposition information pamphlet. This is what Representative Daw was referencing, the 500 words for and against with rebuttals specific to the initiative or the referendum. The work leading up to that the PIP, the Proposition Information Pamphlet, that is an exception to the rule that you can't use public funds. That just makes sense, right? Like, you wouldn't want to punish city staff for putting together what they're required to do under statute. But that was one of the frustrations that we had in the old statute, is that there were parts of the statute that were disconnected from each other and really put, in many cases, city clerks and city recorders in an impossible situation. So we've tried to identify all of those as part of the exceptions. Another key exception is that a mayor or a city administrator can respond to a direct inquiry from a resident about the referendum. In other words, if I'm a resident of the best city in America, Murray City, and there's a referendum happening in Murray.
That's spelled O-R-E-N.
and there's a referendum in Murray, and I emailed Jim Brass, who's the longest tenured member of the city council, and I say, that was not an age joke, by the way, Jim, I can see you're chuckling at that. If I email him and say, what can you tell me about this referendum? Under the old law, he would have been hard pressed to respond. Did it with Mayor Camp up here, up front, or Melinda from Murray. Everyone would say, well, we can't really respond to this because of the old archaic rules in the referendum law. Now, it's a specific exemption to the Public Expenditures and Political Activities and Public Entities Act to respond to that question. So now the council member or the mayor or others can respond to my question. And I'll come back to another thing that they can do in a moment. Well, when you think about a referendum process, a controversial referendum usually comes at the end of a lengthy process. Wade, pop quiz, how many months was the Conwood Mall redevelopment plan considered in Hollywood? And I know there are multiple answers to that.
Yeah. So, by way of introduction, I'm Wade Budge. I represent developers, so I get to work with a number of you. So it's good to see many friends. But to answer your question, in all honesty, we were working on that particular negotiation for 2 years. But from a public hearing standpoint, we started in November and concluded in May. And then we didn't get the answer from the Supreme Court until November. So that gives you a sense of the time frame on that one. And that, what I would say, is a lightning speed process, just because there was so much interest on the project.
So let's take that timing then of 2 years. That's 2 years where city staff is gathering information to elected officials. It's 2 years for the planning commission and open hearings to deliberate, for the legislative body to deliberate. Then the legislative body took action, and within 5 days, petitioners came in and started the referendum process. Now, one key piece of House Bill 119, and this was Representative Daw's focus from day one, was to say that the Political Activities of Public Entities Act starts when those petitioners walk into City Hall and file a petition. Well, again, using the Conwood Mall scenario, you have 2 years worth of effort. All of those reports, all of that research, all of that deliberation basically got put on a shelf once the petition started. What House Bill 119 does is say, okay, here are the rules of the game, holiday council members. The rules of the game are that you may not use public expenditures to campaign for or against a ballot proposition. But here are the exceptions, such as responding to a question, and all of that information that you worked on for a couple of years that informed the elected officials when they cast their vote, that same vote that's being referred. You can gather all of that information, and you can assemble all of that information. And the staff can give that information to elected officials that elected officials can then share through their own personal communication channels. And then on the city website can have a link to all of that information that the elected officials have gathered and put on a website, so long as the city also provides a link to the information that the petitioners have gathered. In other words, the city website can become a one-stop shop for all of the information about the referendum. The city website can have the 500 words for and against. The city website can have the fiscal impact that state law requires. The city website can have the legal impact which state law requires. And fun fact about those two pieces, the fiscal impact and legal impact, state law has always required cities to prepare those. But under the old law, cities would prepare it at the same time signatures were being gathered, and the cities could only share that information with the petitioners. What good does that do for the general population who's going to be considering the referendum, either on their doorsteps to potentially sign a petition or when the vote comes in November? So now, in that pause that Representative Daw referenced, you take the legal analysis and the fiscal analysis, you prepare it during those 20 days, and then it's out in the public sphere for consideration. Likewise, you have to do your ballot title during that period of time. So that way, if there is a dispute between the petitioners and the city, that dispute is happening up front, not at the end. This gets back to Representative Daw's point of like all the adversarial pieces are happening after you've already had the signature gathering. Let's get all that done up front. And then that one-stop shop doesn't just apply to the city website, it applies to any city communication channel. So if, using my hometown of Murray, Mayor Camp does a mayor's message. So in the mayor's message, he could have a link to both sides of the referendum story. And it becomes that one-stop shop for Murray residents to understand the big picture. The more information, the better. Mayor Camp can explain why the city council voted the way they did. Petition organizers can say, here's why we're referring it, and all that information is now available to the general public. So we've got a question here, and then Wade, I'll turn it over to you for voter participation.
So can an elected official actively campaign for or against something on his own email and his own time if he does not use any county funds?
Excellent. This is a key point of what can an elected official do with his or her own email, his or her own time. And the answer is that he or she still has his or her First Amendment rights. So as long as you're doing it through your Gmail account, or you're doing it independent of City Hall, the world is your oyster. Where it gets complicated though, and where there was a chilling effect in the old law, was that constituents are going to often interact with those elected officials through those official communication channels. And so the mayor may get an email from someone asking about the referendum, and it'll be hurry.utah.gov email address, but he was not able to respond to that, otherwise he'd face a potential fine. And so now we've cleaned that up to allow for that response. And then also allow that on the mayor's personal Facebook page or through Gmail account or his or her own website, they can store all of that information that city staff can gather that led up to that ultimate decision. And that leads to the last thing I'll mention too. There was a big improvement in House Bill 119, is that prior to today, if there was an allegation that you violated the Political Activities of Public Entities Act, the only due process, in fact, I can't even, as an attorney, I can't even call it due process. The only lack of process that existed in the code was that the individual who was alleged to violate would go before the county clerk. Well, I've had multiple conversations with county clerks who say, what on earth are we doing adjudicating this? And for those of you who are familiar with what happened in Utah County, it was poor process, and it was driven because of the statute. Well, to Representative Daw's credit, he recognized that, and so the Lieutenant Governor's office will now adjudicate those potential allegations, and there will be due process for that individual. So that's a huge improvement for all parties.
And just FYI, that particular issue is still being adjudicated, and probably will be for a few months yet. So we definitely had to clean that up.
Before I go on to talk about voter participation areas, I do want to tag on to one of the topics that Cameron just spoke about, and that is this process. It is a huge improvement, and Representative Daw deserves a lot of credit for this, to have these issues addressed up front. I'll tell you from having lived the Cottonwood Mall case, it was a huge disadvantage for both the city and the developer to have the city's hands tied so that they could not communicate to the public that this was administrative all along until after a tremendous amount of effort, energy, and hundreds of thousands of dollars were spent on signature gathering. And that wasn't lost on the Supreme Court. If you go and read the opinion, there's a footnote in there where the Supreme Court, because there was an agreement, it's very interesting to see the Supreme Court kind of give us an insight into their own deliberations in a footnote. They talked about how they were not able to come up with a speedy decision because they were trying to grapple with all of these issues. But then what ended up happening is the vote occurred, and once the vote happened, and once the proposition was voted down, then they just came out with a decision that said, as Craig Calls explained, we'll know it when we see it. So what I'm saying here is this, that it's nice that under the new structure, these issues and disputes are to be settled up front before you dispatch all the signature gatherers. You're supposed to have an opportunity for people during the pause to sit down and negotiate or decide whether it's in fact administrative or legislative. If it is deemed to be legislative by the city, the time period starts then for bringing in a challenge. You don't have to wait until after the signature gathering. Now, is it perfect in every regard? Of course not. But we think it's a vast improvement to have that discussion up front and to untether the city so that they're able to engage in that dialogue before people start hiring what is now a very, very expensive process to go out and get signatures. Because we were at this conference that Cameron mentioned last week, and Todd Godfrey, city attorney for Holiday, spoke about how much, and Gary Crane can explain the same thing from Layton's perspective. I'm sure Orem had the same thing. But when you're going through a referendum, it puts a lot of energy in your community. You have a lot of discussions, both positive and negative, on people's doorsteps. And there's a lot of confusion, a lot of myth, and a lot of other things that kind of develop. And it's a good idea to see if we can somehow diffuse that up front with this pause. And so I see that as a big positive from this bill. Real quickly, I think the other takeaway before I jump into VPAs is this. From my perspective, representing developers, if you've got a matter that is going to be subject to referendum, it's really good once the decision has been made to work with the developer on that. And let me tell you why. We weren't able to put this into HB119 because we were so late in the session. But in law, as of today, there is a provision in LUDMA that states that once the signature gathering has occurred, then the developer can, if the developer decided, hey, I wasn't going to sign up for an election, they can come pull their application and it undoes the legislative act. So what that's called is that's called the termination provision. So say, for instance, you have a matter, you're doing performance zoning, and all of a sudden a signature gathering effort goes on, and the developer says, oh wow, I'm now to the point where they were able to obtain the sufficient signatures. This looks like it's going to the ballot. And to the point made over here, the ballot actually won't be until the following year. Well, I don't want to have this property tied up for another year. So what can happen is the developer has a 7-day window in which to say, I'm terminating the project, and that undoes that legislative act. So it makes sense when you're developing these voter participation packets and the rest to work with the developer, at least in those situations, and make sure that everything's proceeding in a fashion that's conducive. But the matter that I was asked to speak about briefly, and
I
go ahead.
just have to say this. This is for me. I have to point this out. This is what I call a proud father moment. Where I get to hear the League of Cities and Towns and the Property Rights Coalition come together and sing Kumbaya to a bill that I I just want to bookmark this by pointing it out. So thank you for your
Very true, very true. Yeah, he did bring us together on this one, so thank you, Representative Daw. So real briefly, the voter participation area has been alluded to, but I think this has been the really significant other item for this coming out of this bill. And what the intent and the policy purpose behind this is this. If you're in a city of the 4th class or higher, then what we want to make sure is that each city has within its boundaries voter participation areas that are, in the definition of the statute, compact and substantially equal in population. And Cameron can speak a little bit more about that from a legal perspective. But the purpose is to have a city draw lines within their city of 4 areas if it's a 3rd or 4th class city, or 8 areas if it's a 1st or 2nd class city. And these VPAs, as we call them, are areas where if I'm a signature gatherer and I'm going to go out and challenge a law, then I need to go out and obtain the required threshold of signatures in at least 75% of those VPAs. So for instance, if we're dealing with 4 VPAs, you've got to not only meet the threshold 17% of the active voters, you've got to meet the 17% of active voters citywide, but also you have to meet 17% of active voters in 3 of those 4 VPAs, or if you're in a city of the 1st or 2nd class, 7 of those 8. Now there is an exception. Oh, 6, excuse me. Yeah, my math's real good. Let's just say this, 75% of the 8 VPAs. That's the more correct way to state it. So at any rate, the item though that's important is there are a couple cities out there though, however, who have council districts already established, and the legislature gives you an out if those council districts, meaning you don't have to create VPAs, if those council districts are actually for a geographic area. If they're at large, then you do need to form a VPA. Now, as we were talking about this among the league and among PRC, property rights folks, the valid point was brought up by a number of seasoned city attorneys. If you're going to go, now everyone has to have, or at least if you're a city of the 4th class or higher, you've got to have these in place by January 1st of next year. The time to do that is early, not when you're faced with a potential ballot proposition or a referendum matter. Because what you don't want is the weight and energy associated with that particular ballot matter or that referendum matter weighing in on your elected officials as you're trying to draw these boundaries. Because there will be a lot of effort and press and push to try and get those boundaries in certain locations. Now the other item I would mention is that the county clerks need to be consulted with this, because a lot of the duties were with the city recorder are now been pushed over to the county clerks in total. So the county clerks are now running the show, not only with respect to advising on, with respect to the precincts and using the precinct lines, with respect to where you would draw these VPAs, but also now as you get later into the process and start handling the matter of submitting signatures and also now submitting removals. That used to be a city function and now that's with the county. So anyway, from a policy standpoint, we think it's a great idea because it encourages people to make sure that they're getting the pulse, if you will, of the whole city and not just a particular neighborhood that might be filling the impact of a particular project. The other advantage is it puts a lot of burden not only on the developer but also on the city in terms of resources. So before you're going to have the city devoting all that money to an election and to all that money to preparing these papers, well, there will be some upfront costs anyway, regardless, but there are certainly greater costs as you get later into the process. And so you might as well make those who are seeking to have a matter referred go through the added hoop, if you will, of making sure the support is widespread enough to justify those costs.
One thing I'll add on the VPA piece is that the VPAs are just trying to be consistent with what state law requires for state initiatives and state referendums. For example, if Representative Daw and the two of us wanted to go grab a couple of friends and do a statewide initiative on medical marijuana, for example, Representative Daw.
Could you pick another example?
If we wanted to do a statewide initiative, we would need to gather the threshold, not just statewide, but in 26 of the 29 Senate districts, which is the equivalent of 90% of the Senate districts. But there was no geographic diversity requirement at the local level. So what we tried to do in House Bill 119 was be consistent with this existing state process for state initiatives and state referendums, which is at 75%. So it's actually lower than it would be statewide, but that was in part because the majority of cities are going to have to draw these boundaries. Wade alluded to that 75% threshold. Going back to my hometown of Murray, Murray has 5 council districts that are already by geography, so their council members are elected by district rather than at large. So in the case of Murray City, the 75% threshold would be 4 out of 5. If you are Centerville City, who's sitting just a few rows behind Murray, Centerville City elects their council at large. So Centerville does need to work with the Davis County clerk to draw these VPAs and try to match the precinct lines. And Derek and Ryan and the panel after us will go into more detail about that. It does only apply, as Wade indicated, to cities of the 4th class and larger. So if your city has 10,000 people or more, then you need to draw VPAs by the end of the year. It will be easier after the 2020 census because the county clerks will be redoing precincts at that time. So we acknowledge that over the next year and a half or so, it's going to be a little tricky. But after the 2020 census, you'll redraw the maps, you'll redraw them every 10 years, and the county clerks will now be on notice as they're drawing precincts to do so with VPAs in mind.
Does the exception for already existing districts also apply to counties?
Yes, yes it does, and it also applies to hybrid cities. So the Ogdens and the Provos and the West Jordans that elect some at large and some by district, all of them have at least 4 districts, and so as long as you have at least 4, then 3 out of 4 would apply.
Any other questions from the group?
Rob Wall, this worries me. Anytime Rob raises his hand to ask a question,
I guess that if you do have council districts, you could still divide them to have 8, or do you have to use the existing 4?
Did you hear that?
Yep, I did. So West Jordan's one of the hybrid cities I referenced. There are 19 cities statewide that could qualify for the district exception to VPAs, West Jordan being one of them. And the statute gives you the flexibility to use the districts or to draw the 8. And that's because West Jordan's a city of the 1st class. Great, thank you.